Good afternoon. You can be seated. The matter before the court is Kennebec 23348, Eastern Maine Conservation Initiative et al. Versus the Board of Environmental Protection et al. We are hopefully being streamed live on the web, both by video and by audio. Let's start by having counsel for the appellant, and then the remaining counsel who will be arguing, introduce yourselves for the record by saying your name together with the party you represent.
Good afternoon, Your Honors. My name is Elizabeth Boepple. I'm here with co-counsel Ellen Wazalski. We represent Eastern Maine Conservation Initiative and Roke Island Gardner Homestead Corporation.
Thank you.
Good afternoon, Your Honors. My name is Robert Martin. I'm here on behalf of the Board of Environmental Protection.
Good afternoon, Your Honors. My name is Patrick Marass, and along with my co-counsel, Rachel McEntee, we represent the permit holder and party in interest in this appeal, Kingfish, Maine.
Thank you. And Ms. Boepple, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Your Honors. May it please the Court. The question before the Court is straightforward. Can the Board of Environmental Protection and the Department of Environmental Protection substitute the issuance of a wastewater discharge permit for conducting an independent assessment under the Natural Resources Protection Act standards of the unreasonableness of the harm that Kingfish's industrial aquaculture facility will cause to wildlife habitats and fisheries? Throughout my argument, I will refer to the wastewater permit as the MEPDES permit and the Natural Resources Protection Act as the NERPA. As we've argued below and believe that this court will agree, the board's abdication of responsibility runs in direct conflict with the underlying principles embodied in NERPA, which is, quote, to protect Maine's rivers, ponds, wetlands, mountains, wildlife habitats, and coastal sand dunes by assessing a project's environmental impact, end quote. It's not just the construction of a facility, but what impact the actual project will have on the environment. To understand the importance of the distinction between the two standards, in brief, what Kingfish intends to do is discharge up to 28.7 million gallons of pollutant per day into Chandler Bay, up to 6.5 million gallons of which will be fish culture and processed water, which includes suspended solids like phosphorus and nitrogen at levels above ambient conditions in Chandler Bay. This discharge includes 1,639 pounds of nitrogen per day. To put it in its starkest terms, excess nitrogen is an eelgrass killer, which is a critical habitat for many marine fisheries. Did the department assess this in its NERPA review? The simple answer is no. Did the board do so on appeal? Again, the simple answer is no. Both the department and the board instead relied on the department's issuance of the MEPDES permit. Why was this not sufficient? Because under the MEPDES standards, the department cannot issue a discharge license to an applicant if the proposed, quote, discharge either by itself or in combination with other discharges will lower the quality of any classified body of water below such classification, end quote. But it nevertheless may do so, issue a permit, that is, if the activity is necessary to achieve important economic and social benefits to the state, and the activity is not so harmful as to cause or contribute to the failure of the water body to meet the standards of classification. In other words, a discharge permit can be granted if the discharge doesn't cause the water classification to drop below its current classification, and the project may provide for social and economic benefits.
Counsel, I see that the green light is on. Isn't the successful obtaining of the discharge permits, though, at least some evidence that the activity is not going to unreasonably harm wildlife, et cetera?
No, Your Honor.
It's
All
not
the-
evidence at all of that?
I'm not saying it's not evidence at all, but the focus of the MEPD's permit process
I understand the
is,
focus is different. My question is, is it nonetheless some evidence?
it's not sufficient evidence, Your Honor. The evidence, what it's focused on is the degradation of the water. And what we're arguing is that's not enough. It's the degradation of the habitat for it's the wildlife habitats and the fisheries that are impacted.
Counsel,
And that's
wouldn't-
what was not
Counsel, wouldn't
assessed.
that have been more properly addressed to the Water Bureau in the MIPD's process?
No, Your Honor, because it's really not within the wastewater discharge permit process that assessment takes place. It's under NERPA. And that is the crux of the problem here, is that that full assessment wasn't done because the department simply looked and said, well, there's the discharge permit, that's good enough.
Well,
But the
it-
standards are very different when you
but-
look at the statutes.
Well, it didn't just rely on the departments, on the discharge permit. It relied on input from IF&W, from DMR. All of those agencies provided information about the impact of this project on the habitat, did it not?
Our argument, Your Honor, is that while there was input from those different departments and different agencies did look at this project, the specific standards under NERPA, and in fact, the purpose of NERPA, is to look at what is the harm to the environment and
So-
do a full-blown assessment of it. That didn't happen.
So let's talk about the standard under NERPA, right? Under 480C, activities requiring a permit. It's applicable here, I assume, is subsection D, correct? 480C 2D, construction, repair, or alteration of a permanent structure. Right?
Your Honor, that's correct, but there is also under, I'm in the wrong section, sorry.
And didn't the board specifically address that standard? And the standard in 480D says the department shall grant a permit upon proper application, et cetera, when it finds that the applicant has demonstrated that the proposed activity meets the standards set forth in sections 1 through 11.
Your Honor, there's also 480D, where the standards talk about harm to habitats and fisheries, and that's what we are focused on. And what happens is, the department does take a look at what they did here was they looked at what the activities involved in the construction of the facility. And what we were asking and what we are arguing is that's not good enough. You have to look at what the long-term effect is going to be once the facility is built and once the discharge is occurring.
So counsel, can I clarify something then? Are you arguing, well, let me back up a little bit. It's my understanding that there was a request for a public hearing in front of the board, but there was not any identification of additional evidence, witnesses' testimony, et cetera, so the request was denied. Are you arguing now that there was evidence that should have been heard that wasn't heard? Or are you arguing that they applied the wrong standard in their consideration of the existing evidence?
We are saying that the wrong standard was applied to the existing evidence.
So you're not suggesting there had to be additional evidence, but that they applied the wrong standard?
I'm suggesting that they applied the wrong standard, and if this court agrees with our argument and sends this back, remands this back to the department, that the appropriate action for the department to take at that time would be to reopen the record and allow for additional evidence to come in.
So you really are arguing that there should have been additional evidence?
Well, since we didn't make that request below, I can't make that argument now.
Okay.
The-
Gotcha.
Is that we came into this a little late in the process in terms of this particular proceeding.
I want to turn back, though, to NERPA itself. What is the proposed activity here that you are suggesting is, adverse to habitat? What is the specific activity?
The activity is the functionality of this facility once it's constructed, which will have a discharge into the waters of Chandler Bay.
In other words, the use.
That's correct.
Okay. Does the use qualify as an appropriate activity under NERPA?
Yes, it does, Your Honor.
On what basis? What's your authority for that?
And the authority for that is Hannum, Your Honor. In Hannum versus Board of Environmental Protection, as this court stated in that case, the use of the structure cannot be divorced from the structure itself.
But isn't the actual holding of Hannum that it's okay to consider the use, not that you must?
That is correct, and what we're asking this court to do is refine that, that legal issue, because we think it is a very important distinction here and should be codified by this court as law, because that's in keeping with the purpose of NERPA.
But it's not in keeping with the statute.
Are you
It
saying
is in keeping with
always?
the statute, Your Honor, with all due respect, if you look at what the purpose of NERPA is.
I'm looking at the language of the statute.
Yeah, exactly.
And the language of the statute defines activity in a very specific way.
Your Honor, with all due respect, there's also the overriding purpose of the Natural Resources Protection Act.
The rule that you're asking us to make, that that the DEP must always look at the functionality and use?
Yes, Your Honor,
So you want us to change the word may in Hannum to must?
that's correct, Your Honor.
Okay.
What I will remind the court of is, and why I say this is perfectly consistent with the statute, and that is to remind you of what the purpose section of NERPA is. It's the intention, quote, "It is the intention of the legislature that existing programs related to Maine's rivers and streams, great ponds, fragile mountain areas, freshwater wetlands, significant wildlife habitat, coastal wetlands, and sand dune systems continue, and that the Department of Environmental Protection provide coordination and vigorous leadership to develop programs to achieve the purposes of this article."
Do we have to overrule and disavow Hannum to create this rule of law you're seeking today?
I don't believe so, Your Honor. I
how would we
believe
do that?
Hannum just needs to be reinforced and clarified with shall rather than,
We're going from permissive
Discretion.
to mandatory.
that's correct, Your Honor.
Okay.
I see that I'm about out of time, so I will just wrap up and suggest that Maine's environment is critically in need of additional protection, which this court can provide through a very simple ruling. And the request that we're making
If
is
it's in
that,
need of additional protection, isn't that a statutory issue?
Your Honor, that hasn't happened yet, and I think it's within this court's purview to do so. So we ask that you consider this, and thank you very much for your time.
Thank you. You'll have an opportunity of rebuttal. And Mr. Martin.
Good afternoon, and may it please the court. Robert Martin, Assistant Attorney General, on behalf of the Board of Environmental Protection. The central question in this case is whether, under the Natural Resources Protection Act, the department is required to reevaluate and reanalyze impacts from a discharge of wastewater that has already been reviewed, analyzed, and permitted under the department's waste discharge permitting program. The answer to that question is no, and this court should affirm the board order for at least 3 reasons. First, EMCI has appealed the wrong agency action here. Separate from the permit at issue in this case, the department issued a waste discharge license for the project in 2021. That permit sets certain effluent limitations and ongoing monitoring requirements of the wastewater discharge from the project to protect, among other things, aquatic habitat and wildlife. EMCI commented on that application while it was pending before the department, but they did not appeal the issuance of it. Now, through this proceeding, they attempt to renew arguments concerning impacts from the discharge. The appropriate forum for their concerns is in the context of the waste discharge permit, and the time to appeal the issuance of that permit has expired. Second, the board and the Superior Court correctly held that NERPA does not require analysis of impacts from the discharge. NERPA regulates certain statutorily delineated activities and requires an analysis of impacts from those activities. Here, consistent with the plain statutory language, the department properly determined that the NERPA triggering activity, construction of an outfall pipe, would not cause unreasonable harm to habitat and wildlife. EMCI's argument that NERPA somehow compels analysis of the discharge has no basis in the statutory text. Third, the board's interpretation of the statute was both reasonable and consistent with this court's precedent. Specifically, the board may, but is not required to look at use impacts, and that courts defer to the reasonable exercise of an agency's discretion in that context. Here, the board's decision to forego a duplicative analysis of the discharge under NERPA was reasonable, given the existence of a separately issued discharge permit, and because to do otherwise would promote tension rather than coordination between the programs that the department is charged with administering. For these reasons, the court should affirm the board order. I welcome your questions.
I'm going to sort of follow up on what I asked counsel for the plaintiffs. It doesn't seem like the board here really separately analyzed the evidence. They just said that the issuance of the discharge permits is good enough for us. We don't have to go any further. And if you follow that to its conclusion, that's like saying, well, it doesn't matter what's being discharged, they have the right, so we just don't even think about that. We just think about essentially the construction of the pipe, the laying of the pipe. Do you think that's accurate, that they didn't really analyze the evidence involved in the discharge permit, but just said that's good enough?
Absolutely, Your
But
Honor.
it is a different standard, so it might be different if they had said, well, here's a whole body of evidence, we're going to take that and then, that evidence, and then apply our statutory standards to that evidence, and that doesn't seem like that's what happened.
So the standards are similar in both of that, in both
But they're
the
not
waste discharge
identical.
context and the NERPA context. But before you get to looking at those standards side by side, when you're talking about what the board did, foregoing an analysis, I think that really gets to the portion of the NERPA statute that appellants quoted here, which is in 480-A, it was the legislature's intent in enacting NERPA that the department's existing programs continue, and that the department continue to administer those programs in a way that fosters coordination rather than conflict between those programs. And here, to interpret NERPA in the way that appellants are arguing would essentially allow NERPA to swallow whole all of the other departments' permitting processes and supersede those. So that's why it was appropriate and consistent with the legislative intent here for the board to not undertake that analysis and rather acknowledge that there's another existing program and that it was the intent of the legislature that those programs continue.
Counsel, we said in Hannum that the board may examine the impact of uses, and that's really up to the board to make that call. What standard do we apply in evaluating whether that's a reasonable call on the board's part or an arbitrary and capricious one?
Your Honor, I think that's similar to the abuse of discretion that this court regularly applies to agency action. The standard there is whether or not the agency's action exceeded the bounds of reasonableness. So as you correctly note, it does get back to the reasonableness of the board's actions, and it was reasonable here.
But when the board is trying to decide whether or not they will step back into the previous decision, I think what we're asking is what takes place behind the scenes? How is that decision made? Is it just arbitrary? I mean, May is such a, I'll ask you first what your interpretation of Hannum is when we said may. You don't have to do this, but you may do it. And we didn't give a whole lot more guidance. What is the tipping point? What's the process that takes place when the board says, nope, we're not going to exercise that prerogative?
So again, Your Honor, I think I understand the desire to sort of tease out a bright line rule here, but this is, again, as the statute notes, it's a reasonableness standard. And this court recognized in the Uliano case, which is another NERPA case, that reasonableness depends on a multiplicity of factors. So there's a lot of different things that the board can look at in that context.
Like what? I'm just,
Yeah, sure. So here, I think the board first starts at what it's statutorily required to do under NERPA. It's statutorily required to analyze impacts from activities. It made that determination here. And then it looks at, and this is one point I think we can, I acknowledge, appellants have a point at. There are overarching goals of NERPA, and you can go beyond the plain language of NERPA when you're looking at those overarching goals and what's in furtherance of those overarching goals. And I think focusing on the particular issue here, the goals of NERPA were served by foregoing that independent analysis or that separate analysis when there's a separately issued waste discharge permit.
So are you arguing that essentially it was rational here for the board not to revisit the issue of the discharge because under the statutory language, it can focus solely on the proposed activity, doesn't have to look at use, and it was rational not to look at use here because discharge issues had already been reviewed by the DEP under the discharge permits?
That's exactly correct, Your Honor. And
Well, then taking it one step further, under 480D3, when we talk about whether the activity will not unreasonably harm, could the board, would it be okay for the board to read that so narrowly that it doesn't even have to consider the use at all? In other words, not even ignore whether or not there had been discharge permits. Let's say the discharge permits had not yet been obtained. Could they say, that's okay, that's not for us anyway?
I think when it gets to use impacts, those are discretionary for the board to consider, and that's consistent with this court's holding in the Hannum case.
And isn't the difference between this case and Hannum the permit, the existence of the MIPD's permit?
That's exactly right, Your Honor. In Hannum, there was no separately issued permit that dealt exactly with the challenged impacts there. I think in Hannum, it was increased boat traffic. So there wasn't a permit there that dealt with, increased boat traffic. In that case, it might have been reasonable for the department to forego an analysis and look at the increased boat traffic and use.
What's the burden on appeal for a party who didn't appeal the department decision, but is appealing the board's failure to go back and look at that decision? What's the appellate standard of review? What do they need to satisfy us with before we grab onto that issue?
Well, I think it's the standard in review is the standard that would apply in a normal ADC proceeding. So as I understood their brief initially, it was that the board's action was an error of law. I think when you get to reasonableness and applying the Hannum standard, you're looking at something that looks more like an abuse of discretion standard. So this is the standard that this court applies consistently throughout in ADC appeals. That's what would apply to the challenge that you mentioned.
There don't appear to be additional questions.
Okay, thank you, Your Honors.
Thank you. Mr. Marass.
Good afternoon, Your Honors, and may it please the court. My name is Patrick Marass, and I represent Kingfish, Maine, the permit holder in this appeal. In addition to the points that Assistant Attorney General Martin just made, I have a few additional issues that I would like to discuss with Your Honors. First, here, I think it's important to remember that the department did fully consider all of the use impacts of the effluent discharge, and it did so through the issuance of the waste discharge license.
Would it matter if they had not yet considered that for this proceeding?
It's my understanding, Your Honor, that the department has the authority to conditionally issue a permit. So if, for example, the premise of Your Honor's question is that the NERPA review occurred before the MIPD's permit, the department can conditionally issue that NIPD's permit subject to that additional final review.
Or conduct their own
sorry,
review of
yeah.
the use, right?
Sorry, Your Honor.
Or conduct their own review of the use?
They could conduct their own review of the use in that context, but the department, for good reason, often relies on that expertise of the Water Bureau and of.
You're not saying that wouldn't have been okay to look at the use in this case. Are you essentially conceding that they really kind of had to look at the use, but that the discharge permit and the process that was gone through with that was a sufficient analysis of the use?
That's correct, Your Honor. This court's holding in Hannum indicates that
Well, I think what you're saying is they didn't have to look at the use, that here there's a rational basis not to look at the use, but I don't think you're saying that if there hadn't been a discharge permit already issued, they would have had to look at the use, are you?
the department is not compelled to consider that use.
Let me just float a probably ridiculous hypothetical. Let's say the department, in issuing the discharge permit, did nothing, just absolutely, there's no way that permit should have issued under the sun. No appeal is taken, comes to the board, and the board looks at that and says, wow, there's no way that permit should have issued. Can they still duck it and say, well, we can take it if we want to, but we don't want to? I'm asking, is there a trigger, is there a tipping point where may becomes a shall?
Well, Your Honor, in that hypothetical, which is very different from the facts
Right.
in this
Understood,
case, where the
understood,
department
absolutely.
fully considered the
Understood.
use impacts. There, I think the department always has an inherent authority to revisit the permits. So if it issued a NIPD's permit that somehow was causing severe degradation of the environment, they have an inherent authority to revisit that. So I think that concern there would be addressed down the road. But again, I don't think that hypothetical situation.
Do you want to briefly address the inconsistency argument raised by the appellants, that this decision is inconsistent with previous decisions? They used a different test.
Yes, Your
Previous
Honor.
board decisions?
Yes, board
Okay.
decisions.
And on that point, Your Honor, I think this court has already addressed the primary point they were trying to make with the CMP order, which is that the board can and sometimes does consider use impacts. This court decided that issue almost 20 years ago in Hannum. And so what the department does in a single permitting proceeding under a specific set of facts should not forever bind the department to that same exact set of steps that it takes, because the legislature expressly gave the department broad discretion to consider what it deems necessary to meet the standards of NERPA.
Is the CMP case even analogous here? I mean, as I understand it, we're talking about the construction of the corridor and the transmission lines. And what the board was looking at there was the ongoing future effects of the construction, of the presence of those towers, not the use of those towers. The use is electrons going through the wires, isn't it?
That's a fair point, Your Honor, and that's not an issue that we've specifically briefed, but I think that the concerns with the CMP order would be holding the department to always looking at the same thing it looked at in a separate proceeding. And so here, the issue that I believe was trying to be made about the CMP order is, look, they considered use, they should always consider use. And our point here is, they did consider the use, Your Honor. They did consider it through the issuance of the effluent discharge. And I see I'm out of time.
Thank you. Ms. Boepple?
Thank you. A couple of quick points. I think it's very important for this court to keep in mind that while we are asking this court to say, no, department, you did it wrong this time, we're not saying there shouldn't be interagency communication. We're not saying that different agencies shouldn't be involved in the process. But what we have right now is a system, or what we have right now in this case is a situation where a permit was used as an excuse not to do a proper analysis under the NERPA standards. And why we're making such an issue out of this is it's also important to remember that the MEPD's standard allows for not just a assessment of what is going to happen to the classification of the water body, but they could lower the standard not below a certain classification if there's this assessment that there's going to be some sort of economic benefit that's derived from this project. Now, we don't have that standard under NERPA. So you don't do that, well, harm to the environment versus, well, we're going to get some cash into the state. That's part of the problem with accepting the MEPD's permit as a substitute for doing that thorough analysis under NERPA.
But in that situation, the NIPD's permit went beyond saying this is just an economic benefit, didn't it? It said that the existing in-stream water use will be maintained, the standards of classification will be met, the receiving waters won't be degraded, and the actual water quality will be maintained and protected. I mean,
Well, I'm sorry, Your Honor, I think that sounds a little bit more optimistic and positive than what they actually found.
Well, that's what it says. That's what
Well,
the
they were
permit-
taught what they were really looking, this is where we get into some of the science, and I am not a scientist, but I understand that there are scientific elements of this which talk about assimilative capacity of the
And
water
people may
body.
disagree, but that was, I think what he was saying is, but that's what they found, even though there may have been contrary to evidence.
And I would also add that the legislature has determined what's reasonable here. And they have introduced some of these other factors that you're talking about, social, economic factors. Those are factors that the department, in this case the Water Bureau, can factor into its assessment as well as what the board can do, aren't they?
That's right, they can do that under the MEPD's permit, but that's not allowed under NERPA. And that's why we've asked you to take a look at the NECEC, the transmission corridor case, which we do think has a relevancy here.
How is that
And the reason we brought
used?
that up,
How is that analogous here?
the reason it's analogous is because the department was focused on construction of the Jonesport Kingfish facility, rather than what's going to happen once it's installed, what's going to happen to the environment once it's operational. The same thing is true of the NECEC. It wasn't just we're cutting the corridor, we're interrupting the corridor for the construction of this line. We are actually going to interrupt it for a long period of time. What's going to happen to the deer corridors? What's going to happen to the wildlife habitat from the forest fragmentation? That is what I'm talking about when I'm talking about the use and why that's a relevant case, and I see I'm out of time. Thank you.
Thank you, counsel. As is our usual practice, we will take this matter under advisement. We'll be issuing a written decision in due course. It's my